everyone, welcome to iExamB. Today in this video, I'll be continuing ahead with our Judiciary Mains answer writing practice. So already ये सीरीज हमने स्टार्ट किया है जिसमें हमने अराउंड 16 क्वेश्चंस को कवर किया है, जिसमें हमने आपको बताया है कि जुडिशरी के मेंस आंसर को जब आप लिखोगे तो किन चीजों को आपको ध्यान देना है. So in this particular video also I'll be continuing with the same. Apart from this, if you have any questions or queries या कोई भी डाउट हो तो आप हमें कॉन्टैक्ट कर सकते हो इस ईमेल आईडी के थ्रू, या आप हमें कॉल भी कर सकते हो इस नंबर पे. इसके अलावा आप हमारी वेबसाइट को भी विजिट कर सकते हो जहाँ पे कि आपको वेरियस कॉम्पिटिटिव एग्जाम से रिलेटेड डिटेल्स मिल जाएंगे, इंफॉर्मेशन मिल जाएंगे. यू कैन सब्सक्राइब टू आवर चैनल एंड स्टे ट्यून्ड सो दैट यू कैन स्टे अपडेटेड. नाउ मूविंग ऑन टू आवर डिस्कशन, जैसे मैंने आपको बताया कि इस पर्टिकुलर वीडियो में मैं जुडिशरी मेंस आंसर राइटिंग प्रैक्टिस से रिलेटेड डिस्कशन करूंगी. सो विल बी टेकिंग अप आवर क्वेश्चन नंबर 17 and the question is, justice demands that a person wrongfully dispossessed of property should recover it. Explain how specific relief act is operating for this purpose. Now moving on to our answer, the very first thing you should remember while going ahead with any descriptive answer writing for the judiciary exam is that you have to remember कि आपको answer point wise लिखना चाहिए. You should actually highlight or underline the very important things which are there in that particular answer, क्योंकि आपने आंसर में बहुत कुछ लिखा है बट उनमें से सबसे जरूरी जो है उसे आप हाईलाइट करो, अंडरलाइन करो. और जब भी आप कोई आंसर लिखने वाले हो उसके पहले अपने दिमाग में आप उसको फ्रेम करो, उसको सीक्वेंस में करो, हाउ यू आर गोइंग टू राइट दैट पर्टिकुलर क्वेश्चन, व्हाट ऑल यू आर गोइंग टू कवर इन दैट, एंड देन यू स्टार्ट राइटिंग द आंसर. अपार्ट फ्रॉम द इम्पोर्टेंट थिंग्स व्हिच यू हैव टू रिमेंबर विद रिस्पेक्ट टू द आंसर राइटिंग, यू हैव टू include a synopsis wherein you will be giving an introduction with respect to the topic which has been asked about in the question. Then in the body part you will be including recovery of possession of property as per section 5 and 6 of the Specific Relief Act, and then there should be a conclusion based on जो भी आपने introduction और body में लिखा है उसका conclusion आपको देना है, crux देना है in this particular conclusion part. Now moving on to our detailed discussion of the answer. Introduction में आपको mention करना है about the Specific Relief Act. तो basically Specific Relief Act से related question है, तो a little bit of introduction with respect to that will be a good idea when you are attempting the answer. So basically आप लिख सकते हो कि Specific Relief Act जो है वो provide करता है equitable remedy. तो equitable remedy क्या हो गया? Basically the act it is actually aiming to provide for the exact fulfillment of the terms of the contract or the terms and conditions which the parties they actually agreed to. So आप देख सकते हो provides for equitable remedy wherein the court issues an order requiring the party to perform a specific act, thereby directing the performance of the contract as per the terms and conditions which the parties agreed to, rather than the payment of compensation or damages for the non-performance of the contract. So in case breach हुआ है and all, so Specific Relief Act के according courts जो है वहाँ direct करेगी, exact fulfillment of the terms करवाएगी, equitable remedy provide करेगी, and they will not be ordering or directing the payment of compensation. Thus the aggrieved party is granted the very same thing to which he is entitled to rather than the monetary compensation, because आप ये भी elaborate कर सकते हो यहाँ अगर आप चाहो तो कि monetary compensation is being covered under the Indian Contract Act. So this particular act is focusing on an equitable remedy. Further you can mention कि specific relief is thus granted on the principles that damages are not adequate remedy, or in all the situations the damages or monetary compensation are not adequate remedy, and so specific relief or specific performance is granted by the courts, and they are being granted only for the enforcement of individual civil rights. So basically section 4 इसके बारे में mention करता है provisions, तो आप यहाँ पे section 4 को भी state कर सकते हो. Then हम body part पे आएंगे जहाँ पे कि हम बात करेंगे recovery of possession of property, and that is according to section 5 and 6 of the act, which provides the method of recovery of possession of certain specific immovable property. Further section 5 को पहले हम elaborate करेंगे and then moving on to section 6. So section 5 of the Specific Relief Act, that is providing that a person who is entitled to the possession of specific immovable property may recover it in the manner provided by the CPC. In other words, this section lays down that any person who is the lawful owner of a property can recover the possession of such property by due course of law if he is dispossessed of it. इसको भी आप highlight कर सकते हो, important है. Then thus it means that when a person is entitled to the possession of specific immovable property, he can recover the same by filing a suit as per the provisions of CPC. The very essence of this particular section lies in the title, that is the person who has a better title is a person entitled to possession, and the title may be of ownership or it could be of possession, either of these. And further we'll be moving ahead and you can write about section 6 of the act, which lays down the provisions provisions with respect to the recovery of the possession of property by a person who is dispossessed without his consent of immovable property otherwise then in the due course of law. Accordingly, this section is only applicable if the plaintiff proves that he is in the judicial possession of the immovable property which is in dispute. He had been dispossessed of the immovable property without his consent and without the due process of law. So these the plaintiff actually has to prove. Then dispossession actually took place within 6 months from the date of the suit. So these you will be further you will be mentioning कि जो remedy available है person जो कि dispossessed है अपने immovable property से illegally is what is the particular section is providing for. The very object of the section is to discourage forcible dispossession on the principle that disputed rights are to be decided by the due process of law and no one should be allowed to take the law in his own hands, however good the title may be. Further आप mention कर सकते हो कि जो section 6 है वो clearly provide कर रहा है summary, cheap and useful method या remedy to a person who is actually dispossessed of any immovable property and that is actually not as per the due course of law. So basically what it is doing, it is providing that if any person who is dispossessed without his consent of the immovable property, the person may by a suit recover possession notwithstanding any other title which he may set up in such a suit. But no such suit for recovery of possession of immovable property under this section shall be brought after the expiry of 6 months from the date of dispossession or against the government. So this also you can mention. Further आप state कर सकते हो ये particular case law which is MC Cocklingham versus Monica Vasingam. Supreme Court ने यहाँ ऑब्जर्व किया जो सेक्शन 6 है वो प्रोवाइड करता है पर्सन को अगर वो लैंडलॉर्ड है तो भी दैट ही कैन नॉट टेक द लॉ इनटू हिज ओन हैंड्स एंड फोर्सिबली evict a tenant after the expiry of the lease. तो चाहे वो लैंडलॉर्ड भी है he can not take the laws into his own hands. This was what Supreme Court observed in this particular case and it frowns upon the forcible dispossession without recourse to law but does not at the same time declares that possession of the evicted person is lawful possession. Procedure under this section is summary and its object is to prevent self-help and to discourage people to adopt any foul means to dispossess a person. Dispossession of a tenant should be in accordance with the law. Further जो है when we are done with the body part we will be coming to the conclusion. So हमने जो introduction और body में cover किया है उससे related जो भी important aspects है हमें अपने conclusion में mention करना है and so we can write that from the above discussion it can be concluded that the remedies provided by the Specific Relief Act becomes essential. Why? Because the Indian Contract Act provides relief only in the form of compensation in case of breach of contract. So Indian Contract Act हमें क्या provide करता है कि अगर breach of contract हो गया तो damages दे देगा, monetary compensation देगा, but damages हर केस में जो है वो adequate नहीं होता है, ascertainable नहीं होता है and so compensation in the form of relief they are not adequate to the loss and so the plaintiff has no remedy for specific performance. So this particular act is providing that. Therefore, through the provisions of section 5 and 6, a person who is entitled to the possession of immovable property or having a special right to the possession may recover it through the due process of law. This is what all you will be covering in this particular question. आप answers को अपने और भी enhance कर सकते हो उसमें और case laws cite करके, examples cite करके. So with this we come to an end of our today's discussion. Do remember to stay tuned to the channel so that you can make your preparations 50% faster with us at our exam.